Hello, everyone, and welcome to Internet Law Review. For today's story, I want to cover this article, which is from CBS News, dealing with the fact that Florida's governor recently signed a bill to ban so called sanctuary cities. So, we're going to read a little bit from this article, and then we're going to use that as a platform to discuss some of the legal issues that it refers to, because there's some very interesting areas of law that deal with the interaction between states and the federal government, and this article provides us a platform to discuss it. So let's see what this article says and then discuss some of the legal issues that apply. Quoting from CBS News, all law enforcement agencies in Florida will have to cooperate with federal immigration authorities under a bill signed by Governor Ron DeSantis on Friday during a ceremony that often felt like a campaign rally for him and President Donald Trump. The legislation prohibits local governments from enacting sanctuary policies that protect undocumented immigrants for deportation, which no Florida cities have actually done. Local law enforcement will be required to honor U.S. Immigration and Customs Enforcement detainers for undocumented immigrants who are arrested or convicted of a crime. The bill exempts crime victims and witnesses. So you might be wondering, wait a second, doesn't a state government have to cooperate with a federal government? Doesn't federal law reign supreme? Doesn't a state have to cooperate? What's the point of this? Don't they have to do it anyway? Well, the answer is actually no. State governments don't have to cooperate with the federal government, and we're going to cover a little bit as to why that's true. The first place that we should start is with the 10th Amendment to the Constitution of the United States, which states that the powers not delegated to the United States by the Constitution nor prohibited to the states are reserved to the states or to the people. So, what is that talking about? Well, it's basically saying that as a default issue, all power, all rights belong to the states. So when the states started in their first instance, they were states in the exact same way that the nation state is a state. That's why they got that name. And as nation states, they had the right to do anything nation states could do. So that would be basically everything. The US Constitution changed that relationship, however. It did two things. First of all, it delegated certain powers to the United States federal government in the Constitution by giving them power to do certain things. And it also, by its text, prohibited states from doing certain things. So it both gave the federal government explicit power and took the power away from the state to do certain things. So their previous unilateral absolute authority was made more compromised. But the Ninth Amendment reflects this balance. It's basically saying the states still have all the power except for the power that was given to the federal government or power that has been denied to the states. So the presumption is that states have all the power. So, what are these powers of the federal government, you might ask? Well, of course, the Constitution tells us some of these designated powers. And this is Article 1, Section 8, which deals with the acts that Congress may pass. So, what can Congress do? And it lays out various provisions. But the one that we're interested in for today is Section 4, which states that Congress has the power to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcy throughout the United States. Obviously, bankruptcies are not the provision we're interested in today. We're interested in the uniform rules of naturalization. And so, what does that basically mean? It means that the federal government has the power to establish all rules with naturalization, how to become a citizen, who are citizens, who are not citizens. Congress has the unilateral and sole power to make those determinations. So, Congress has the power to determine if someone is a citizen or not, and no state can establish it because Congress has the right to make uniform rules, absolute rules, and no state can interfere with that. So this would be an example of a provision where the state doesn't have this power because the federal government has been given it, and by implication, the state has been denied it. So if the federal government has all the power dealing with immigration, all the power to determine who are and are not citizens, all the power to determine who are naturalized and who aren't, what does that mean for the states? Do the states have to cooperate with that? And the answer to that question is no. The reason for that is due to a principle known as commandeering. The federal government has the right to pass the laws it wants. The federal government has the right to have the police it wants to enforce its laws. But the federal government does not have the power to force state governments to assist it or to use its legislative or police apparatuses to assist the federal government. And there are many cases which stand for this proposition. I'll refer to just one specifically because I think it's the best case on point that refers to this concept, the case of Prince v. United States. In the case of Prince v. United States, the federal government had a provision that required the states to have certain laws as it dealt with handgun and handgun violence. But the federal government, Supreme Court, ultimately ruled that this was unconstitutional because it commandeered the state authority. So it was unconstitutional because the federal government was requiring the states to do certain things, and they can't do that. If they want to have laws, they can do it, but they have to enforce it themselves. So Prince v. United States is an example of the case holding with this commandeering doctrine. Another more recent case dealing with this principle of commandeering doctrine is this case, Murphy versus NCAA, which was a 2018 case. In this case, the federal government had a law that prohibited states from having rules dealing with sports gambling. The United States Supreme Court ruled that this was unconstitutional for the exact same reason. The U.S. federal government cannot impose on the state legislature as to what its laws are. The federal government can have its own laws, it can have its own enforcement mechanisms, but it cannot commandeer the state legislature, cannot commandeer the state police. So the state can have its own laws, the federal government can have its own laws, and the federal government can't impose on it. So this is another recent example of this doctrine being applied. Does this mean the federal government has no power to influence state law? Is there nothing the federal government can do to help get the states to do what it wants to do? No, it doesn't mean that either. And the best case on point is South Dakota versus Dole. As you may be aware, in every single state in the United States, the drinking age is 21. But strictly speaking, it doesn't have to be that way. It only is that way because the United States Congress has politely asked the states to do this. Well, how have they politely asked them to do this? By saying that if they don't do it, they're going to withhold 5% of federal funding for highways and other sort of infrastructure relating to interstate highways. So there's absolutely nothing precluding a state from making its drinking age 18 or 12 or 5 or any other number they want to be. They can do that if they want to. The only consequence is they have to give up 5% of their federal highway funding. Now, it just so happens to be that 5% of the federal highway funding turns out to be quite a lot for the states. And so they don't really want to give up their 5% of federal highway funding. So the drinking age in every state is 21, but only because they want the money. If a state were to make the drinking age lower than 21, you might wonder, can the federal government increase that 5% to a higher number? Well, South Dakota versus Dole does say that it can't be such a high number as to be coercing. It can't be so high as to be basically an offer you can't refuse. And although South Dakota versus Dole didn't explicitly set out a percentage, it somewhat implies 5% is getting towards the high end of what is tenable. What is actually tenable, of course, is completely undecided because it's never come up. No state has ever tested this. But South Dakota versus Dole does seem to suggest that much more than 5% would be unconstitutional. Where the line is, we don't know, but there is definitely a limit where a state can force the issue. So, returning to the issue at hand with Florida, what does this all mean? Well, it means the federal government, of course, has the power to decide who is and who is not a citizen of the United States. And they have the right to decide that on a uniform basis. And they have the right to say that a person who comes here through particular methods is not here legally and must be deported. All that being said, it does not give the power of the US government to force states to do their bidding. Of course, immigration law is not the only example where this is true. Another good example where this is true is the current ban dealing with marijuana. The US federal government has a policy that marijuana is a class 1 drug and therefore is banned, and has said that it's illegal for anyone to possess it anywhere. And the US government could use its police forces to arrest anyone in the United States who has any possession of marijuana whatsoever. All that being said, no state has to help. So the state of Colorado, for example, has a pretty open policy when it deals with marijuana. And the federal government so far has said, we'd really like it if you make marijuana illegal in your state too. And the state of Colorado said, well, that's nice. Thanks for the input. We're not going to do that. And nor do they have to. They don't have to do it. And the federal government so far has not provided any sort of South Dakota versus Dole type incentive to get them to do it. Theoretically, they could. They could attach certain provisions of federal funding related to law enforcement support to the ban on marijuana to sort of influence them to pass the laws that they want. That hasn't happened yet. And so at the moment, hypothetically, there's nothing stopping a DEA agent from going into a marijuana dispensary in Colorado and arresting everyone in sight. But there's absolutely nothing requiring the state of Colorado or its police to help. And they're not particularly inclined to help, as you may have noticed from their current legal posture. And exactly the same thing is true here dealing with immigration law. There are quite a few states who have taken a somewhat more open view to immigration than the federal government does. And some cities have established what they call so called sanctuary cities, which basically says, in so many words, that we're not going to help the federal government. They can come by and they can arrest people if they want, but we're not going to help. We're not going to tell the federal government about anyone we suspect to be illegal immigrants. We're not going to honor any sort of detainers, which incidentally is just sort of a request. It's not a warrant. They probably would be required to obey a warrant. But a detainer is simply a request. And so they can ignore those. And they particularly don't have to help by alerting the federal government or assisting or arresting people or doing anything else. So the state of Florida apparently before this would have allowed a city to pass a similar regulation and say, well, we're not going to assist the federal government. But cities are creatures of pleasure of the state government. The state government can force cities to do absolutely anything they want. They have absolute authority over the cities. And so here they're basically saying, even though none of you have taken advantage of this sort of loophole, we're just going to go ahead and close it in advance. We're going to tell you you can't be a sanctuary city. We're going to tell you you have to honor these detainers. We're going to tell you you have to cooperate with the federal authorities and give them information. And basically that, if the federal government comes around and wants help, you have to give it to them. The state of Florida is absolutely free to not do this, and it's free to do this. It's Florida's choice, the same way it is every state. And Florida, in this particular situation, is saying, yeah, we're willing to help. So if you come along, we'll try to give you some assistance. They don't have to. The federal government isn't offering them anything to do it. They're just doing it because they feel it's the right thing to do. And they have absolute right to do that too. It will be interesting to see if any other states follow Florida's lead and pass similar laws saying that its cities and counties also have to cooperate on the same terms. Once one state does something, it makes it a lot easier for other states to do something. It's this whole like no one wants to be the first one to do something, but once there's a first, it becomes a little bit easier. So I would suspect that other states will follow this. Now, how many other states and what states will follow this? I don't begin to know the answer to that question, but I would imagine there will be other states who adopt it, and this will become a difference of state law, states that want to help and states that will tell the federal government to get lost. But they each have the right to do that. And it will also be interesting to see in the future if the federal government, through its regulations, tries to put pressure on the states to adopt these laws, perhaps by denying them surplus equipment or denying them access to federal assistance in law enforcement or denying them access to other sort of federal facilities. Again, this would have to be a non-coercive amount, so it would have to be something in like a 5% ballpark figure. But the federal government could hypothetically do that. They could absolutely do it by law, by an act of Congress, which seems less likely at the moment. To the extent that the federal government's executive branch can do it by executive order is unclear. That would have to be authorized by some act of Congress. But presumably, there's some flexibility for the executive to decide who they do and do not give surplus equipment to, for example. So the president of the United States may be able to do some of this unilaterally. I don't know how much, but we'll see once other states begin to adopt it if they want to put that kind of pressure on. Of course, even if they do, there's nothing precluding a future president from changing their mind. Only an act of Congress could force the position, so we'll have to see what the future brings. But for now, my friends, that's all. I hope this has been a helpful summary of the separate sovereigns doctrine and help you understand a little bit about what the federal government can require states to do and what they can't, and the flexibility states do and do not have when it comes to dealing with requests from the federal government. So until later, my friends, I hope you're well. Cheers and goodbye.